Right, good afternoon, everyone. As I said, thank you very much for coming along to our Next Recover webinar presented by our non-accidental partners, Colin, Moffat and Richard Pitts. Just a few bits of housekeeping before we get started. Our webinar today will be recorded and the slides and the video will be distributed to yourselves afterwards via email, so you can feel free to share that, rewatch, share it with your colleagues, whatever. If you do have questions throughout the presentation, feel free to stick them in the Q&A or the chat box and we can get around to them at the end. If you do have any questions after the presentation as well, get in touch with myself. I can pass them on to Richard and Colin and we can circle back on those too. And yeah, without any further ado, I will pass over to Richard and Colin and they can take us away.
Sure, thank you. Good afternoon, everybody. Thank you for joining us. As Stuart said, I'm Colin Moffat. This is my colleague Richard, and we are two of the partners in Digby Brown's non-accidental team. The intention this afternoon is to give you an overview of the different types of claims that fall under the non-accidental injury title, and some of the traps and pitfalls that you can fall into, and hopefully an idea of the benefit and the value that we can add for your clients if you come across these cases. Begin with a little about the team. Across Digby Brown's offices, we have 16 fee earners working in the non-accidental side. We are Scotland's largest team of specialist abuse lawyers by quite some way now, and we're only expecting that to grow over the next couple of months. In the last year, we're pleased to say that we've recovered £21 million in damages for clients, and that's in the last 12 months alone, which should give you some indication about not just the truly horrific scale of the problem, but also the real change that personal injury lawyers and pursuers agents in particular can bring to people in this area. In that last year, we've paid 11,000 in referral fees out to Recover members. That, of course, depends on the damages that are recovered. So the very simple pitch here is if you do have clients coming in your door, please make sure to think about Digby Brown and pass the clients on to ourselves. And I'll touch very briefly on some of the pitfalls that can come up further down the line. In terms of the department work profile, what does non-accidental injury mean? Well, we cover a whole range of cases, the very obvious historic abuse claims, both personal injuries actions and the redress scheme, assaults at work, road rage. We also cover criminal injuries compensation scheme cases, military claims under the Armed Forces Compensation Scheme, and I suppose anything else that has a deliberate slant to the wrongful conduct. Moving you on now to a bit more detail about the nature of these cases, and I'll start with some of the historic abuse claims, which, as you'll all know, have become a bit of a fad, certainly in the papers, and something where there's a degree of focus given Lady Smith's ongoing inquiry. It's a significant volume of work. It accounts for about 58% of our team's current case holding. And as I said, with 16 fee earners, you can anticipate just the volume of survivors that we're trying to help. The law in this area is largely governed by the changes under the Limitation Childhood Abuse Scotland Act 2017, which, as you'll know, removed the time bar, so that's your normal 3-year limitation period, for claims relating to abuse, which was suffered by the victim while the victim was under the age of 18 years. Straight away, that should be jumping out at you as slightly different. Why is it 18 rather than 16? And that seems to be to create some congruence with the criminal injuries scheme. Of course, it's not entirely an open goal. It's open to the defenders to argue that on an individual basis that they are subject to substantial prejudice, or that the court cannot hold a fair trial. In simple terms, the easiest way to think about that essentially is the burden has been flipped. The traditional role, it was for the pursuer to persuade the court that the claim should be allowed to continue after limitation. Now it's the other way around. Defender arguing in the individual case that too much time has passed, not enough documents have survived, or other barriers. At present, there is very little guidance from the court on the application of the substantial prejudice defence. Realistically, the only reliable guidance we've got is that the death of an alleged perpetrator will be a significant barrier, although the court has been very careful to stress that it's not an absolute rule. You'll probably anticipate that the battleground at the moment is finding exactly where that line is between the very obvious cases where we have a convicted abuser, many of whom you'll be pleased to hear are presently serving long jail sentences, and those cases against unknown abusers or where they have already passed away. That's something that I think is a particular advantage to having a large team, as we're able to gather in and collate a significant body of evidence around other victims and group information about prolific predators, even in cases where Police Scotland or Crown Office either have not yet taken action, or as many of your criminal practitioners will anticipate, where the pace of progress is rather glacial. Most of these cases are going to turn on the issue of vicarious liability. How do we hold an organisation responsible? Your starting point there, as you're all familiar with, is the two-stage test that was most recently summarised and restated by the Supreme Court in the trustees of the Barry Congregation against BXB, usually referred to as BXB in short. As a quick summary, you all know the two-stage test, and that is step one, that there must be a relationship of employment or akin to employment between the wrongdoer and the defender or the potential defender. Most of the time, that's quite straightforward, but it's important to stress that it can be a relationship akin to employment. So this does cover situations including prisoners who are working in prison kitchens. It includes volunteers, for example, the Scouting Association, and in a recent judgment, it was also held that it potentially could cover work experience students and other volunteers. The second stage of the test is where the real problem comes in, and that is the close connection between the wrongful conduct and the specific tasks and duties that were delegated by the defender to the perpetrator. It's not enough to show that the defender worked in the location where the abuse occurred, or that they were an employee or during the course of their employment. You've got to show some connection between what they were supposed to be doing and how that increased the risk of the abuse or the wrongful conduct occurring. That's usually quite straightforward in the role of teachers and care workers, anyone with a pastoral element to their job. That's going to be much harder for ancillary or support staff and those are cases such as janitors, gardeners, or kitchen staff. So a good knowledge of the facts of your case will be crucial to determining vicarious liability. Who generally are we bringing our cases against? Well, as I said, that's normally institutions. Common defenders will be local authorities, usually for the care homes and foster carers. Religious orders, they tend to be older cases looking into the 60s and 70s. Names like Nazareth House will probably be very familiar to many people joining us this afternoon. But it also includes private schools. Fettes College, Edinburgh Academy have been topical recently, and indeed Richard has been involved in a number of cases very recently involving Melville House and the Mertland School. The Scouts, another perennial favourite, but just underscoring that this includes voluntary organisations as well. The big issue with so many of these cases, of course, is the question of insurance and being able to track down the assets of the organisations that we are pursuing. There's an ongoing issue with a private institution in Aberdeen who may or may not have the assets to pay out in these cases. Why is that problematic, and why should a civil case always be the first port of call? It is the harder case, and there's no shying away from that, but the level of damages that are recoverable in these situations is substantial. And I mentioned a Digby Brown case, AB against the English Congregation of Christian Brothers, which remains Scotland's highest award for damages presently in these cases, where £1.4 million was awarded to the pursuer. The salation or the injury component of that award was just shy of £100,000, nearly doubled with interest. And for anyone quick off the mark, you'll appreciate that the vast majority of the final award for the pursuer came from the loss of earnings claim. That, in our view, is why it's essential that these cases are handled by specialists, because it's very easy to go wrong with this, as I'm about to touch on, with the most common alternative to historic abuse claims. And that is Scotland's redress scheme, which hopefully you will have all heard about. Certainly the now First Minister put a lot of effort into making sure everyone knew about the redress scheme and telling us that it was a direct alternative to the court. I will leave you to your own opinion after my comments this afternoon as to how accurate that assessment is. Redress, of course, is a Scottish Government scheme, so the advantage to your clients will be that there is definitely a pot of money out there to pay their damages. It's also fair to say that the bar or the burden of proof for redress schemes is much less than you would face with the courts. So in simple terms, redress is a more straightforward case. It is a simpler case and one that your client is much more likely to succeed with. The balance to all of those benefits is in the damages. And as you can see on the screen, the redress scheme is a capped system. It pays damages up to a maximum value of £100,000. That's not just a capped assessment of the case. it's important to realise that redress is only able to consider what we would call the nature of the abuse. So that is the acts that have been committed against a child or a survivor. It includes a broad range of things, from emotional abuse and neglect right through to physical and sexual abuse. But as I say, it's only the abusive acts that are considered. Redress is not able to take into consideration the consequences of the abuse. And very often you're dealing with survivors with lifetime problems with poor mental health, anger and addiction issues, and as we saw a moment ago with AB, it's very, very significant impact on their education, their employability, and their lifetime earnings. So getting the decision whether to pursue a civil damages claim or go down the redress route is absolutely crucial to properly advising your pursuer. And that's important because for 99%, it's one or the other. I forgot to mention the last connecting factor, or really the key connecting factor with the redress scheme, is that the pursuer was a child in care at the time. Why does that matter? Well, if you compare this with a civil case, as I mentioned earlier, to blame an individual defender, the defender must be vicariously liable for the individual wrongdoer. Redress is a much broader scope. In a single redress application, provided your client was in a relevant care setting, you can apply for and receive a redress payment for all of your client's allegations of harm and abuse suffered by that person while they were in that care setting. The perpetrator themselves or the perpetrator's connection with the care setting or the care provider is irrelevant. It doesn't matter if it is a care worker, if it is other children in the care setting. And if you've come across these cases, you'll know that bullying and violence between these kids sadly was absolutely rife. But it also includes abuse by people in the community. And I don't want to strain too much into the topic of grooming gangs, but that is not a modern phenomenon. And you will see that in records and in survivor stories, and that falls under the redress scheme. There are a couple of other limitations with redress on the definition of a relevant care setting. It excludes short-term care settings. So respite care, holiday care, or short-term placements are excluded. Again, for anyone who's been keeping up with the press, you'll recognise the name Fernethy, which was a placement usually where children, a lot of young women, were sent sometimes for 6, 7, 8 weeks to give them a break from their parents over summer. Many of them suffered very horrific abuse, but that's not covered by the redress scheme. The other limitation of the redress is one of time. Redress only covers abuse that was suffered up to December 2004. If your client's allegations occur after December 2004, they will not be eligible for the redress scheme. Their alternatives will be either a civil damages claim with all of the challenges that brings to proving the abuse, or the criminal injuries compensation scheme, which Richard will discuss with you in a few moments. The biggest limitation to redress, as I said, for the majority of people is the choice, civil or redress, and which one do you pursue? The Scottish Government elected to maintain the very controversial waiver provisions. We have a situation where various organisations, every local authority, care homes, charities, were invited to pay into the pot to fund the redress scheme, and many of them have done so. It's a condition of the redress scheme that if you accept a payment of any amount, you must sign the waiver. And the waiver requires your client to give up for all time their rights to pursue any civil damages claim relating to allegations of abuse. Now, hopefully the pedants that all lawyers are will have caught just how vague that statement was, and I do mean it in those terms. The waiver covers any allegation of abuse against a scheme contributor, whether or not your client has disclosed those allegations or even included them in the redress application. So your clients, unfortunately, cannot cherry pick their cases to put their lower level allegations against redress and maintain their good quality claim against Glasgow City Council. It's all or nothing. There are very limited situations in which you can do both. The only example I think we've come across recently has been quarriers, and anyone in the kind of Renfrewshire and Ayrshire area will likely know that name. The quarriers, despite its scale and its involvement in the child abuse inquiry, have chosen not to contribute to the redress scheme. Now that's beneficial to victims in the sense that quarriers' victims can still apply and can still obtain redress through the government scheme. However, if they do so, they are not prevented from later pursuing a damages claim against quarriers if they're able to find sufficient evidence. But as I stress, that's unique at this time to quarriers because they have not contributed to the redress scheme. If they were a scheme contributor, Glasgow City Council is a good example. If your client accepts the money from redress, that's it. They cannot pursue their claim against the council regardless of the quality of the evidence. And that is, and I mean to belay the point here, absolutely crucial that you get this right when advising your clients. Because as we've touched on, the maximum your client will get from the redress scheme is £100,000. The maximum that they can get from the Scottish court is, in theory, unlimited. And as we have seen, the damages that our clients are recovering through the courts are, on average, above £100,000. And indeed, Richard has a number of cases on the go at the moment, including one against an otherwise large and well-known Scottish firm who will remain nameless, who failed to give that advice, and their unfortunate client ended up getting less than half of what we were able to recover, or a contemporary in near identical circumstances. It's a difficult question and very easy to get wrong. So if you do come across that situation, please reach out to us and make sure that you're giving your client the right advice. Those are the main types of civil claims, but of course we do cover a variety of other claims that have a deliberate element. There's the really obvious road rage cases. These are, for the majority, your straightforward road traffic claims. There can be some indemnity issues, so a good knowledge of the Road Traffic Act and dealing with the Motor Insurance Bureau can come in here, but the law around winning the case will no doubt be well known to most of you. The department also covers claims with the Protection from Harassment Act. They do tend to be a smaller portion, mostly because it's establishing insurance. Showing vicarious liability in that area tends to be very challenging. And the remaining area, probably our next biggest cohort of cases, is assaults at work. And that will cover a range of ideas that are probably very familiar to you. Service user and patient assaults on staff, very often nurses and hospital porters. Assaults on teachers, which, again, if you're keeping up with the newspapers, you'll see certainly is a growing problem. The law here is, at least in my view, very inadequate. These are hard cases, and trying to establish liability against the local authority is very challenging. Again, a large team means we've got a good body of evidence on the scale of the problem, growing scale of the problem, it has to be said, and the various council policies to try and find a consensus about how these matters should be dealt with. Of course, if that doesn't work, there's often a fallback plan, and that's the criminal injury scheme, and I'll hand you over to Richard.
Good afternoon. For those of you not familiar with 1980s hip hop, the graphic there is KRS-One and Scott LaRock of Boogie Down Productions. That is widely credited with being the first gangster rap album circa 1985. Scott LaRock is also mentioned on Guns Don't Kill People, Rappers Do by Goldie Looking Chain. Meanwhile, criminal injuries compensation is, as it sounds, a statutory scheme to compensate the innocent victims of crime. At present, the most recent incantation is the 2012 Criminal Injuries Compensation Scheme. It's set out and is relatively clear in its terms, although there are a number of difficulties with any government scheme. It's to compensate the innocent victims of crimes of violence. Now, all of those innocent victims in crimes of violence have their own pitfalls. There is a very tight definition as to what is a crime of violence, and some things such you would think might be included, such as voyeurism, aren't considered crimes of violence. It's a question of what constitutes an innocent victim is one for which there is a lot of tribunal appeals. The process, incidentally, is that you apply to the scheme, you then seek a review, and you then appeal to the first tier tribunal, would be Social Entitlement Chamber, and after that is judicial review. We've undertaken judicial review in the past, so we do full representation up to and including tribunal, and if push comes to shove, judicial review on the back of that. We have a team of experienced solicitors and paralegals who regularly undertake that, including one member of staff who used to work for the authority. So the question for us is always, can we add value? We very much pride ourselves on being able to get the right awards for people in the difficult cases where it's a question of what tariff award applies for the injury. Is there loss of earnings? What is the care claim? We don't believe that below offer relatively straightforward cases that we can reasonably do so. If we don't believe that we can add value, then we'll tell you how you can apply yourself. Ultimately, you don't need a solicitor to apply for criminal injuries compensation, but our advice is that above a certain level, then frankly you do, and you should. The maximum award under the scheme is £500,000, and we regularly obtain six-figure settlements for people under the scheme, but it's not straightforward. There are a number of knockouts in the scheme, the knockouts being previous convictions. A community payback order unspent can actually knock you out altogether. I was faced with a rather unedifying situation of a man who testified against his abuser when he heard some 25 years later that someone else, a young girl in this instance, was making the same allegations about that man. So he got very drunk, got arrested, and then in the process of being processed, confessed to what had happened to him. He was praised by the judge at the resulting trial for his courage in coming forward, and he'd saved a young girl from being abused, and his assailant got 10 years. He got a community payback order for his drunken behaviour, which knocked out his criminal injuries claim. That's very, very unsatisfying, to say the least, and there is activity at a parliamentary affairs level on lobbying to change the terms and conditions of the scheme for victims of abuse. But at the moment, that is currently falling on deaf ears. It is very, very harsh. The other thing to consider is, of course, that if a claim, the time limit usually is 2 years from the date of the incident, or 2 years from your 18th birthday, or 2 years from the date of reporting to police if the incident occurred in childhood, you report as an adult. Now, if a claim is if a conviction, is capable of being unspent before the 2 year is capable of being spent, before the 2 year time limit expires, then it makes sense to delay the application. And you could, if you get that wrong, you could of course be held professionally negligent in those circumstances. So it's another rather nasty pitfall. Conduct is an issue. Very often I will Google a client, particularly if they can't give me an explanation about how the fight started. The one such case involved a fatal claim brought by relatives, and I Googled the deceased, and I found on social media that he had advised his assailants to bring weapons because he was coming armed. He had in fact not merely started the fight, he had organised it. So that was in fact a straight knockout. Reporting must be as soon as reasonably practicable. As a rule, it's usually within about 48 hours, sometimes a week, depending on the circumstances, but as soon as reasonably practicable. And you must do all you reasonably can to bring your assailant to justice. Now, in cases such as domestic violence, where there may have been several involvements of the police, the question about what doing all you reasonably can is one which we've taken to tribunal and argued in the past. So it's worth noting that with these cases, you can end up going to tribunal on eligibility. Eligibility, if it's decided in your favour, goes back to the authority to decide on quantum, and you're back to square one all over again. So these can be long-running affairs as far as it goes. We've had a number of arguments about what it is everything is reasonably practicable, particularly in the case where somebody was in reasonable fear of reprisals. So there's also the possibility of the assailant benefiting. You've got to show that the assailant can't benefit, and in a domestic violence situation, that's often something we end up in an argument about. Criminal injuries claims are not straightforward. They are not particularly generous. Even if you can prove loss of earnings, and there's a series of criteria about that, then they are at statutory sick pay rates. Furthermore, for anything like for care claims, for example, you've got to show that it's over and above what is freely available elsewhere. Failure to consider both of those issues, however, is an area in which we have taken professional negligence claims against other firms before. The most notorious example of that is D against Victim Support Scotland, which I was the principal solicitor in, where we sued Victim Support Scotland for failing to consider a loss of earnings claim. It's a point of pride that that case was condemned by no less than Suella Braverman. Moving swiftly on before we get to political military claims. This is a relatively new area of business for us. We've taken some unsolicited inquiries, and it's something that we're looking to develop. There's an option here for the Armed Forces Compensation Scheme or to sue the Ministry of Defence directly, or rather the Advocate General for Scotland on behalf of the MOD. You have the Armed Forces Compensation Scheme, which is a bit like criminal injuries compensation, but slightly more generous. You have to prove that the injuries were caused by or aggravated by service. And the MOD will dispute everything, so you will inevitably end up at tribunal for pretty much everything. Again, it's review and appeal to, in this case, to the Pensions Appeal Tribunal. As I say, for injuries caused or made worse by service. Civil claims in that case vary from ordinary workplace types. For example, I've got a slipping case on an army base that wasn't properly gritted despite a forecast of snow. That's sort of standard workplace claim almost, through to operational issues. I acted, for example, for the parents of a soldier shot dead and alive firing exercise. And we currently have some cases involving operational issues on submarines. Beware, of course, of combat state immunity, which the MOD likes to plead even if it's got no reasonable chance of getting that through. There are some questionable areas at the moment as to what constitutes a battlefield. For example, would a drone operator in Bryce Norton be covered by combat state immunity as they're not in the immediate field of battle? Really, I'll keep that relatively short, just in case there's anyone has any questions. I appreciate that's a remarkably wide-ranging session.
Yeah, Richard and I sometimes have a tendency to waffle, so I thought we would keep some of the.
What do you mean?
Some of the
fronted.
Some of the more challenging questions or comments to the very end. So please forgive me if I'm jumping back and forward a little here. Richard mentioned the significant limitations in value under the criminal injuries scheme. There was recent research by APL, the Association of Personal Injury Lawyers, which showed the significant difference that legal representation can make to victims, and the significant increase in awards that are available on review. So while as good practitioners we know that there's no such thing as always rejecting the first offer, statistically a review decision shows an increase of 504% for applicants who are legally represented. Whether that is how good we are as lawyers, or how shockingly the CICA are undervaluing claims at first instance, I suppose is dealer's choice. Another factor to consider, and maybe relevant with the cost of living crisis, is the differing impact of insolvency on your clients. The criminal injury scheme, as a matter of statute, any award paid is inalienable. So any sums paid to your client do not vest and will never vest in the accountant in bankruptcy, and will not affect your client's entitlement to means-tested benefits. The same is not true of civil awards. That's, of course, subject to all of the normal rules. And the redress scheme sits somewhere in the middle. The Scottish Government secured various concessions from the DWP so that redress payments will not affect your client's entitlement to means-tested benefits. And as you'll all be familiar, what that means is where your client has more than £6,000 in capital or other assets, their entitlement starts to degrade, and once they go above £16,000, they lose their entitlement to means-tested benefits in full. The redress payment will be disregarded for your client's lifetime. But a redress payment is not protected from insolvency proceedings. So where your client becomes bankrupt, or if they are still within the 4-year acquirenda period, even after discharge, the trustee can seek reappointment and can seek to claw back those sums. And given the very substantial damages that we are talking about, it's very, very likely that the trustee will seek reappointment, and likewise, usually very difficult to negotiate any sort of agreement with the trustee. Where there's time issues about applying, that creates yet another layer of risk to your clients in, do I apply now, and which route do I choose to go down? All of which I hope underlines the importance of getting good quality advice right at the start. And I think it's essential that your client's story is interrogated from all of these angles, because the Scottish Government has done a lot of very good work in getting the redress scheme out into the public consciousness. But certainly my experience, and I'm sure Richard has had the same, we have a large volume of inquiries coming in, a lot of the time from solicitors on the Recover network, where clients are seeking advice on the redress scheme, and we are very quickly able to advise them about their other options. And indeed, a lot of these cases have been converted into civil claims, where the clients, as I mentioned earlier, are quite often ending up with 2 or 3 times the level of damages that they might otherwise have got had they first went down or only pursued the redress route. So please forgive me a moment, because we can't quite see all of the screens, so I'm going to stop sharing the slides to see if there's anything in the questions. It doesn't look like anyone's given us any written questions. Stuart, you'll confirm that for me.
Yes, I do. I have one question I'd like to raise, if that's okay. Obviously, your department and the cases and the clients you deal with, it's can often be a very sensitive matter. These people have gone through a lot. If you could talk about it from a client care perspective and how you and your department kind of deal with that and anything along those lines, I think that'd be really interesting to hear how you tackle that aside from general other personal injury cases. Like, how does this department deal with those issues specifically?
Sure, you've managed to pick the wrong person to ask that question. Our colleague Catherine Hammonds, one of the associates in our Edinburgh office, Catherine is accredited as a Law Society specialist in trauma-informed practice, and certainly would be better placed to answer that question than Richard and I. But dealing with survivors is very challenging. We've all had experience, I suppose, in any case, of clients that are a bit more anxious or a bit more highly strung. But with abuse survivors, that unfortunately is the bread and butter. You're invariably dealing with people who, for very clear reasons, have lifelong problems with anger and problems with trust and building trust. And it's usually those people in authority above them that caused the very harm that you're claiming for.
And very often, I should say, that they've been through the criminal process and then come to us. And by that time, they've probably had enough of lawyers in the nicest possible fashion. So, yeah, it's something. I mean, trauma-informed practice is something that we work very hard at. We work very hard at reviewing our practice and looking at the way in which we do things. When we set the department up in 2016, the way that we did things was very different then to the way it is now. And the main emphasis is on not re-traumatizing the client if you can possibly avoid it. There will be an element of re-traumatization because we're going over particularly difficult and unpleasant things as far as that goes, but there are ways and means to minimize that to the best of our ability.
And we've kind of achieved that, or try to achieve that, through the training of our staff in trauma-informed principles, but also making sure that we have a cohort of experts, psychiatrists, psychologists, and employment experts who are experienced in dealing with trauma survivors and victims of abuse. And that carries right through into the selection of advocates, both senior and junior counsel. And over the sort of 10 years that we've been building this department, we've built, I think, a pretty solid body of experts and counsel that we can rely on to understand survivors and engage with them at a level that the survivors is able to cope with and can understand. But I suppose, like any client, there's going to be days you get it wrong.
Brilliant. Well, thank you very much, Colin and Richard. I really appreciate you taking the time. If there's no other questions, we can just call it there. As I said, I will be distributing the recording of this session in the next couple of days, so please look out for that in your email address. And yeah, thank you again, Colin and Richard. Appreciate it. And have a good afternoon, everyone. Thank you for coming.
Thank you.
Thank you for your time.